Hello, my name is Sarah Sheikh and we are now continuing on with the DV Hot Talks training. And overall, this is part 4, but this is part 2 of the DV Hot Talks training. So continuing on with the interview, this screen asks about why the children need protection. Now, in this section, it is specifically the children, but overall, this section is for any third parties. So it says describe the reason why, and it gives the names, but this could be your roommates, and I keep on saying your and you, but of course this is more, this is as if I was talking to the petitioner. So if I do slip back into that mode of speech, just ignore that. So this is about any third persons the petitioner wants protected, may it be children, roommates, family members, and if there was no one else they want protected, the question would literally say, describe the reasons why, and it would actually have if you look at the actual question right here, it says describe the reason why, and there would be no third persons, and it would just say in addition to Mary Jane Smith. Now, this is a very tricky question because what happens is that volunteers will then fall into the trap of thinking that this question is asking about the petitioner, but it really is intended for the third parties. The only thing is, if there are no third parties, it would just skip to our petitioner and cause the confusion. So once again, this section is only about any third persons who need protection, and the program will ask you, why do these third persons need protection? In this case, we can put down that in our scenario, it's RP has been abusive towards me in front of our children. RP's behavior affects our children's well-being. It could be that RP has been harassing them. It could be that RP has made threats to their safety. RP has been physically abusive. So whatever the reason is, it's going to be that reason that goes in here for why those third parties need protection, not why our petitioner needs protection, because our declaration, which you're going to help the litigant write later on in detail, will detail the reasons why the petitioner needs protection. This question asks about does he have a weapon, and we want to put down as much detail as we can about the weapon because it's really for law enforcement safety. If an officer goes out there and is about to serve a restraining order, or if they go out here to have the party move out and serve the restraining order, then they need to know that there may be a weapon on that property and there may be a weapon near this person. The next question is, do you want to ask the do you want to ask the court for custody orders? And this goes to actually getting the litigant orders in court regarding child custody and child visitation. And one thing you want to tell the litigant is that it's better to have orders right now through this restraining order than to leave things up in the air, because anytime there are gray areas and rooms for arguments and rooms for doubt, it leads to more stressful situations as well as maybe the opportunity for more abuse on the restrained person's part. So if a litigant tells you that I already have a divorce case open and I'm going to get orders in that case, or I already have a paternity case open, I'm going to get orders in that case, you want to let them know that if the restraining order is granted, they can get same-day orders and get permanent orders as early as 3 weeks. And they might want to go down that route rather than leaving anything up to uncertainty about whether the other parent has rights to the minor children in terms of any visitation or child custody. Another thing is if there are already family law orders in place and the petitioner applies for a restraining order but does not change those family law orders to reflect the new abusive situation, then those orders will remain in place. So for example, if mom and dad already had a case open and mom got custody of the children, but the father had weekend visitation and it was every weekend, even if there was some sort of abusive situation and the mom got a restraining order protecting herself and the children, that weekend visitation would stay in place. So this is a chance for someone to either get orders or to modify, or in other words, change orders that they had previously gotten. And the next question asks, do you know of any third parties who claim to have rights over the children? This question once again goes to any other cases. Are there guardians out there that we have to worry about? Are there foster parents that we might have to worry about because there's a children's court case? So once again, this is another way of finding out if there should be any other party or any other court involved in this restraining order situation. If you mark off that yes, there are third persons, this screen will come up and it will ask you their name, address, and what rights do they have to the minor children. This is a screen that warns the litigant what's going to happen. It tells them that they get temporary orders for the next 3 weeks, and basically what's going to happen is that they're going to, in this cooling off period, if they've asked for no visitation, have a chance to think about whether there will be visitation, whether it will be monitored, who's going to pay if it's going to be monitored, who's going to take the children to the visitation and bring them back, and whether it's for the exchange of the children will happen at a police station, at the curbside. So there are lots of details they have to think about in this 21-day period. And like I said, most litigants will then default to having no visitation for at least the next 3 weeks. The program asks what custody orders do you want, legal custody, whether it will be the petitioner, the other parent, joint, or someone else. Same thing for physical custody, which is with whom the children will live the majority of the time. Once again, petitioner, other parent, jointly held by both parents or another or a third party. Then it asks who, if you as the parent, the petitioner, have physical custody, will the other parent have visitation? And the petitioner can here decide if they want no visitation or if they want some sort of specific visitation. If they say no visitation, you are going to mark off the box, the circle that says will not have visitation. If they say that they do want visitation, you will never pick option 3 as your reason, as an option. You're always going to pick number 2 for visitation because that fills out the forms that we need, which is the DV-105 and the DV-140. And the petitioner will be asked to decide if they want visitation up to the hearing and after the hearing. And if they're not sure, feel free to mark off for after the hearing. We can mark off I don't know. Who does the minor child live with now? And really this question is going to both children in this scenario, but basically the court needs to know that they have jurisdiction over the children. California law states that the minor children must have been in the state for at least 6 months before this court can have any right to make orders regarding those minor children. In our scenario, we say that they've been living there from January 2008, but basically we want to provide the addresses for the last 5 years. The most important address is the current address. Where has the child been living currently? But previous to that, we can put down just city and state, and we can even have the dates ranging as in years rather than putting down exact month, date, and year. In this scenario, I did pick January 2008, but it does give you the options. Let me just go back. In this area right here, it does give you the option of putting down the year and the exact month. And so if we went back 2 years with one address, we'd have to go back one more address to find out where the child has lived for the full 5 years, which depending on whenever you are watching this training, it would be 5 years from that date. This next question asks, please tell the judge the reasons why you are asking for this custody and visitation order. And this is really asking the petitioner if what they're asking for is in the best interests of the minor child. Now that means that not only does the parent who's here today doing the paperwork, not only do they have to tell the court why they are a good parent. You know, I'm the primary caretaker. I feed them. I bathe them. I take them to school. I take them to their doctor's appointments. So what makes the parent who's here today a good parent, as well as what actions make the abuser a bad parent. I've left the children alone with the other parent, and when I came back, they were hungry and dirty. He has abused the minor children in front of me, or he has abused me in front of the minor children, rather, and maybe he's also directly abused the minor children. So all those details would go into this section because this is to convince the judge that yes, the orders that the parent is asking for are orders that are in the best interests of that minor child or minor children of that relationship. The next question is no travel orders. It asks, do you want to ask the court that the party not leave the state or county, whichever one you want, not leave those places without either court permission or the other parent's written permission. This goes towards controlling where the the abusive parent can move with the minor children, either within the county only. Maybe if you pick other, you can do it within the city. But basically it says anytime they go outside of that limitation, they do have to get the court's permission. Child abduction. So this is a question that's very, you as a volunteer would want to err on the side of caution. So if a litigant says, I want to do it, we would do it. But really, what has the other parent done to make you believe, either directly or indirectly? Or what have they done, said, or threatened to make you believe that they are capable of committing a felony and kidnapping the child and leaving the state? In this case, whatever they tell you, you help them fill out, but it really is up to the judge if they're going to order those abduction prevention orders. What the benefit of that is, if there are abduction prevention orders in place and the other party does disappear with the minor children, then the district attorney's office of Los Angeles County is then ordered to locate and retrieve the minor children and bring them back to the custodial parent's custody. The litigant can then ask for that they not, well, initially it asks for what are they basing that fear on. We have whether the other party has violated a past order, if there's been some sort of criminal record, not having strong ties to California. Did they recently quit their job? Did they close accounts? What things have they done to make you fear that? Also, they have a history of domestic violence, or maybe not cooperating with you in parenting or taking the children without the parent's permission. So it asks for the basis of what that fear is, and then the next screen asks for specific details. What have they done directly or indirectly to make you believe that they are capable of doing this? From there, we can then begin asking for orders. Well, where specifically do you fear that they'll take the children? County, state, and country. And then what ties do they have to those different locations? And we can then begin with the orders, asking the court to order the other side to maybe register this order or notify the embassy or consulate of foreign countries so that the embassy or the consulate is on notice that there is an order in place regarding minor children. We can ask the court to order the other side to post a bond, not to move away with the minor children, turn in any vital documents like passports, that they not be allowed to travel. If they're allowed to travel, though, that they be forced to turn over like an itinerary, addresses, and things like that. So it gets very specific. And I would highly suggest that all of you you have the link, because it's in part 1 of this Hot Docs training, but part 3 overall. You have the link for the program, and I would suggest you get on there, and even without signing in, going through the interview to get an idea of what these questions are. Because when the litigant ends up asking for abduction prevention, it can get very dense. And we want you to be able to explain this to them without sitting there and reading everything, which does kind of delay things as well. The program then asks for other things like no travel. Then what area do you feel them comfortable moving within? Is it the county? Is it the city? From there, we go into now other orders. We've taken care of all the child custody, visitation, abduction, travel orders. And now we're in the other orders that you can get through a restraining order. This is property control. So with the move away order, the move out order, you can get control of the home, the shared home. But property control is for any other items. For example, the black Toyota Camry that you share. Or it could be all of the personal belongings located at this address. Or it could literally be the actual address itself. I want exclusive control over the property located at. And basically you want the court to order that, and then in the declaration portion, which is going to come later, you can then detail why you need that piece of property. The next question is about property restraint. If you remember, we talked about if the couple is married, then we can ask the court to order the other side to not destroy or hide or sell any community property that they both have equal rights to. We also have debt payment. Debt payment is asking the court to order the other side to make any necessary payments that are called necessities of life, for things that are necessities of life. For example, the rent, utilities, for food, things like that that are absolutely necessary for you to have in order to be able to live comfortably. And this next screen shows you how it would be. It would be you have to put the name of the individual that needs to be paid, for what, when is the payment due, and how much is it. Now, sometimes the litigant will tell you, I know that I need the rent paid, it's this amount, but I'm not sure who it should be paid to. We can then ask them to try to figure it out, but since that's not a priority because the emergency is the restraining order itself, we can also put down the name of the litigant. So then the payment would directly be made to the petitioner, who would then pay the rent on to the management in some way. The next screen then talks about insurance. So if the parties share insurance and health insurance, and you can even try for car insurance. If they share insurance and the petitioner is afraid that the other party will retaliate by removing them from the insurance, we can ask the court to order the other party not to be able to not remove them from that insurance. And if you look at this, again, look at the actual question itself. It also talks about life insurance policies, like changing beneficiaries as well. The next question is about damages. This is what we did talk about a little bit in detail previously, but this is damages, for example, for missed work, doctor's bills, damage to property, the cost of fixing something, temporary housing that they might have had to get. This next screen then asks the litigant to put down who to pay, for what, and the amount. Now, at this point, the litigant might tell you, I have no idea because I haven't been to the doctor yet, or I haven't gotten the bill yet. They could say, I'm still staying at the hotel, so I don't know how much it's going to cost overall. Have the litigant estimate something. This means that they can estimate a ceiling amount, 10,000, 5,000, but whatever it is they pick, that is, as I said, a ceiling amount, which means that they cannot get more than that. So if a litigant puts down $5,000 for car damage, but then the car ends up costing $5,200, and they come back to their hearing and they bring the receipt, the bill for $5,200, and the court can only grant them up to how much they asked. So whatever amount they estimate will become their ceiling amount. So have them put down something and have them put down a high amount so that they won't be limited by what they have put down once they bring in their receipts and bills, which they will have to do to the hearing in order to get these orders. Pet protection. Sometimes, and actually quite often, I've seen situations where the abuser has abused the pets of the petitioner in order to terrorize or harass the petitioner who's here today for the restraining order. So in this section, we can ask the court to order protection for the pets that the petitioner might own due to a past history of abuse that the abuser might have perpetrated against those animals. This next section is for, do you want to ask the court for any other orders? Any other orders literally means that, but you do have to be careful in wording the other orders. In this section, the litigant can ask for anything, but they do have to be, like, for example, if they ask that the court order the other side to return the garage opener as well as the vehicle's keys, it cannot be, I am asking the court to order respondent 2. It really should be like an order from the court, because the same language gets populated on the request as well as the actual temporary order. So we want to ask the court to, and it should say, respondent shall return petitioner's garage opener and keys to the home within 24 hours of service of the restraining order. So in this other order section, you do have to be very formal and write the order as if a judge was making the order. This is the child support section. It asks, are you self-employed? And then it jumps to what kind of form do you want to fill out? And right here, I am going to tell you that you should always be picking the income and expense declaration form. The income and expense declaration form is a very detailed form, and we want our volunteers to pick this form because it would then, once you pick by hand, it would print out. And then you can give that form, the empty form, a blank form, to the petitioner so they can come back and get help with that later on. Once again, our priority is not to help the petitioner with their financial forms, it's to help them with their restraining order forms. So once the litigant is done, they can come back and get help from an office called the Family Law Facilitator's Office. from an employee of the court called the family law facilitator. These employees of the court are there to help litigants fill out their financial forms. It's a free service, and as long as the litigant goes and files their case and gets a case number, they can come back and get help with the financial form from these facilitators. So once again, you're going to pick the space, the line that says income and expense FL 150. You're going to pick the section that says by hand, and you're going to then give the litigant the blank forms with instructions to come back and get help later on after they file, but before their hearing. This next section asks if they want to ask for spousal support. Spousal support or alimony is an option if the parties have been married. And in this scenario, we did pick that they were married, and so the litigant can then ask for this, and once again, they'd have to come back and get help with the financial form later on. Finally, this is the second confidential physical description section that you see. This is the program is a bit weird. Sometimes the screen will show up, sometimes it won't. I haven't quite figured out when it shows up versus when it doesn't. But this is the second time it's showing up is because the program will now ask you to put in our petitioner's information. It is completely optional, and so the litigant does not have to do this if they don't want to, but you also want to tell them that it's also completely confidential. This information is going to show up on a form called the Confidential Law Enforcement Telecommunications System Form, CLETS 001. And that form goes to the law enforcement, and it goes into their database so that when they search a name, this restraining order would pop up, and it would show the name and description of our petitioner and the name and description of the respondent and anyone else who's being protected. And so it's really for law enforcement. It's optional or confidential, and really it is up to the litigant if they want to provide this information or not. From there, once again, the program asks, do you want to file this restraining order in your divorce case? And in this case, you're going to say no if you don't have the case number. And finally, you've reached the very end. It says you are done with our questions. You're going to click finish below to continue. So as you can see, there's a big arrow right here that tells you to hit finish. And then when you hit finish, you get into this screen, but this is very, very important. Do not get your document. You're going to put in our litigant's name right here in the section, last name versus last name. Description you can put down, like I put down training sample, but you can put down domestic violence restraining order, and then you have to hit save answers. You must save this. Once you save it, you go to the next screen, and the next screen will then tell you, get document. When you get the document, you will get a PDF. Now, once I click on that, I'm going to get the PDF, and I will show that to you in one moment. So this is the PDF that opens up once you hit Get Document, and it's actually a PDF of all the forms that you are going to be printing out for the litigant. The first thing that pops up is an intake questionnaire, and we don't really need that at all. That's just for the backup attorneys to look at. But then we have the DV-100, which is a request for the domestic violence restraining order, which sets out the request. Here we have, do you want anyone else protected? What is your relationship to the other party? The next question asks, are there any other court cases? We have personal conduct orders and stay away orders, and the move out order. So basically, this is the petitioner's request of everything they want from the other party. We then continue on to recording unlawful communications, pet protection, child custody, child support. And the forms just list everything that we filled out, and the request itself is 5 pages long, along with an attachment for other debt payment that the litigant wants. We then jump to the child custody forms, and basically what it does is it sets out the parents, the children, who has legal custody, who will have requested physical custody, where the kids have lived for the past 5 years from the birth to present, if there are any other custody cases, other people with or claiming to have rights to the children, and what kind of visitation the litigant wants. In our sample, we did put down something specific so you would get an idea of what would happen if you put something specific down, but notice how it's day, time, what weekend, when does it begin. So it's very specific. It also goes to who's going to pick up and drop off the kids, where the drop off and pick up will be, will there be supervision. So sometimes there might be errors because we didn't actually go through the supervision questions, but you can definitely make changes on the forms itself. I would never, or none of the backup attorneys would ever expect you to go back into the program to make those changes unless they were very, very extensive changes. We have the travel with children right here, and it says that dad cannot leave the state of California with the minor children. This is the case cover sheet which the court would use to figure out what kind of case it was, which right here it says domestic violence, which can be filed in any courthouse. That's what that means. And this is the ex parte notice telling the court that they don't, no notice given, because they're afraid that the violence would reoccur. So this is where that information gets filled out. We then jump from that into the CLETS form, which is the California Law Enforcement Telecommunications System Information Form, and it tells the law enforcement that there is a restraining order protecting Mary Jane Smith from John Andrew Smith and the minor kids. We also have the income and expense declaration, which is completely blank except for the captions. And what that, remember, is we're going to hand this to the litigant and they're going to come back and get help with it after they file their restraining order and get a case number. We have the notice of the court hearing. So when they file this restraining order, they're going to get a comeback date of 21 days later, which will be filled out right here in this section. And they're going to get some sort of decision from the court, whether it'll be all granted, all denied, partly granted, or partly denied. And from there, we can skip to the actual temporary order. If you look at this carefully, it looks exactly like the request itself. It has the protected persons. And then from there, it has personal conduct orders, it has stay away orders, but notice that there are boxes up here for the judge to decide whether it will be denied or whether it would be granted. Same thing for the move out order. It's up to the judge to decide. And then we have recording unlawful communication. Anything that was not requested is marked off not requested. And the judge would then mark off whether it's denied or granted up until the hearing. We also have the child's custody orders, this is the actual order, which says sole legal and physical custody. It says specific visitation for the other party, and pick up and drop off, and no travel. This is a proof of service. So if the petitioner had his or her friend personally hand the paperwork over to the restrained person, they would then fill out this proof of service, and number 5, 6, and 7 with the date, time, and address. Well, number 5 would be when and where the documents were served. The server's information goes in this section right here, down to the telephone number. And then the server, under penalty of perjury, signs dates, prints, and signs in this section right here. This is the proof that the other party was served, and then the other party can either show up to the hearing or not show up to the hearing. We have the DV-120, which is the blank response. Remember, if you remember from part 2, I did say that the blank forms are also printed out, and then these get handed to the server so they can hand the copy of the restraining order along with the blank forms to the restrained person. Finally, we have the restraining order after hearing. Restraining order after hearing, which the litigant brings with them to the hearing in 21 days. If the judge grants a permanent restraining order, that restraining order would then be, this would all be filled out by the judge and signed so that the court, so that the litigant is protected for however many years they grant this restraining order for. And we have additional, we have another 140, DV-140, which is the blank form for the court to fill out with what their actual permanent orders will be. And then finally, we have cover sheets. These cover sheets, this one's in Spanish because we said that we needed a Spanish interpreter, but we have them in English, and I believe we also have them in Armenian, I believe. And so this sets out the procedure. They're going to go file in the clerk's office, right? And so we would write down the clerk's office right here. They would then go to the courtrooms to have the judge decide on the temporary restraining order. They would then have to have someone, a sheriff or someone, serve the copy on the restrained person, And then it says, well, if you have children and you're asking for custody visitation, you're going to go to mediation on the day of the hearing. If you're asking for child support, well, then you're going to go to the family law facilitator's office to get some help with the financial forms. It says prepare for your hearing and then go to your hearing. So this flow chart would then be slapped on top of the restraining order petition and the temporary orders. There is a specific order that the forms should be in, and you're going to learn that at the center as you go along. We have a forms, let me just show you really quickly the order of forms. So we have an order of forms list that's on the, let me just open this up a little bit. So it's available at all the sites, and basically it sets out how you should be ordering the paperwork for the court for ease of the judge to look at. And when you go in on your first day or your second day, maybe even your third day, you'll be shadowing someone who can teach you how that particular courthouse prefers their forms. And then from there, you'd get an idea of what your specific site will be requiring from you. And then finally on here, the PDF, we have instructions for the second section, which is about the blank response, which is the TV 120, and the proof of service. And we have the cover sheet for the restraining order after hearing forms, which basically say forms to bring to your restraining order hearing. So once you exit the interview, the hot docs interview, for the first section, you hit finish and you save, you get this PDF, and this is a PDF you're going to save on the desktop and then email to the backup attorney. Or like I said, if the backup attorney is on site, you would then just bring it over to the backup attorney to review. Any changes you make would then be made on the forms themselves, unless, like I said, they are extensive changes where it might just be better to go back into the program. And if you have any questions, you can always ask your backup attorney, your more experienced colleagues. But most importantly of all, ask your backup attorney if you have any questions. So this is the end of the training for the DV Hot Docs program, part 2. It's the end of part 4. Please continue on to part 5, and we will talk about declaration writing and the statement of details of the abuse.